Alright guys, now I'm going to teach you something that a lot of states have a huge issue right now with your constitutional rights, that they're not keeping up with case law. The person that usually does that for each state is the legal team comptroller that makes sure that the states are compliant with the state, with the federal laws and case laws and keeping those up to date. Well, here's the thing. Let me read why. Mr. Crenshaw took and entered the home without a warrant, nor was there any harm or probable cause to take and do so. Now, where do we find those things? And we can find them all over. That's called in the Tennessee Facts Report. Now, when you get your copy, you'll have a copy that says Case Recording Summary. This one here freely admits that he took and entered the home and interviewed the family and children. Now, I'm going to cover something here that this is case law. It is unconstitutional for CPS to conduct an investigation and interview of a child on private property without extenuating circumstances or probable cause. The decision in the case is Doe et al. Versus Heck et al. And this was in 2003, case number 01-3648. And it specifically says, this is a decision of the 7th Circuit Court of Appeals, found that no prior consent interview of a child will ordinarily constitute a clear violation of the constitutional rights of the parents under the 4th and the 14th Amendment of the United States Constitution. According to the court, the investigation and interview of a child constitutes a search and seizure. And when conducted on private property, that means your residence or where you reside, without consent, a warrant, probable cause, or extenuating circumstances, such as an interview, is unreasonable search and seizure in violation of the rights of the parents, the child, and possibly the owner of the private property. Now, let's clarify some things. The mere possibility of danger does not constitute an emergency or extenuating circumstances that would justify a forced warrantless entry and a warrantless seizure of a child. Hurlman v. Rice, 2nd Circuit Court, 1991. A due process violation occurs when a state-required breakup of the natural family is found solely on the best interest, we'll say, of the child, as they like to say, analysis that is not supported by the requisite of proof of parental unfitness. That's Quallen v. Walcott, 434 U.S. 246, 255, and 1978. Okay, what does this mean? This means a CPS person cannot take and knock on your door and come in your house and interview your child. It's a violation of your constitutional rights. They are going to talk around it, they're going to try and play games and everything else with it, but it's not going to work. Why? Because this is federal case law. That means the states have to take and follow it. So if this has happened to you, your constitutional rights have been violated. And you need to go to the local district attorney's office and report this crime. Now, they can find the evidence of this, once again, in the previous document I showed you, in their Tennessee Facts Report or in that report, because they just snitch on themselves, because they give the address and what they did. Not hard to find. Now, I'm in Tennessee. Tennessee courts have consistently held that police entry or CPS or anybody from the state entry that's upon private occupied fenced land without a warrant and absent exigent circumstances, unreasonable, and evidence obtained as a result, such a search must be suppressed. That means if they come in illegally, if they happen to find anything or anything like that, it can't be used. It's called the color of law. That has to be suppressed. Why? Because that's deprivation of your rights under the color of law. Hence, the other term that they use is a legal term. Anything from that point on is considered fruit from a poisonous tree. Hence, it's not admissible in any court.